So, Asha, did the Supreme Court's ruling completely end nationwide injunctions?
It's complicated. I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal and national security analyst.
And I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. So, we got our decision in one of the long-awaited cases for this term last week, and I think it's worth parsing because it is, I think, complicated because there's the actual issue as it applies to the particular case it came up in, and then there's the bigger issue about nationwide injunctions and how they're going to apply generally.
Yeah. Oh, not nationwide. I'm sorry. Universal injunctions.
Oh, yes. It's universal injunctions. Did you use that too?
Yeah. That was very, the Justice Barrett was very particular on that point.
Yeah. So, yeah, I mean, maybe we should just set the stage here. Obviously, Trump issued this executive order, which purports to essentially reinterpret the 14th Amendment to the Constitution, and particularly the clause of who is subject to the jurisdiction of the laws of the United States, and essentially change the meaning of who would then be a U.S. citizen as a matter of birth, as the 14th Amendment guarantees. And there were 3 different lawsuits that were brought to challenge this executive order. There's individual plaintiffs, there's associational plaintiffs, there's state plaintiffs. And I think it's important to distinguish that there's these different kinds of plaintiffs. And all of the courts that looked at this said, First of all, I think at least one of the judges outright said this is crazy pants in terms of the actual merits of the case. But because the merits aren't going to be decided for a while in terms of whether the EO is itself constitutional, the courts all issued nationwide injunctions, which meant that the EO could not be enforced on anyone anywhere. And so basically, the Trump administration could not put this executive order into effect. And I just, as a matter of context, I did look this up, Renato, and I know that the Trump administration has really made a big deal about nationwide injunctions, and these are the courts trying to stop us or whatever. But nationwide injunctions have been around for a while. Under President George W. Bush, there were 6 nationwide injunctions. Under Obama, there were 12. Under Trump's first term, there were 64, so amounting to over 1/2 of the 127 injunctions issued since 1963. So true, the majority to Trump. And even in Biden's last term, there were 14 nationwide injunctions. And so I just like to highlight that this is something that has been used to essentially stop the enforcement of policies of Republican and Democratic administrations going back for a while. And it's true that Trump has, there have been more that have been issued in response to his, but I would argue that his executive orders are more fundamental changes to our everyday understanding of the law, the 14th Amendment case being one of the birthright citizenship case being one of them, which probably accounts for that disparity. What do you think?
Yeah, I mean, first of all, I think it was really important, Asha, that you set that context, because if you're somebody who has been watching or listening to this podcast for a while, you'll remember that there were times during the Biden administration where we were talking about these injunctions. And there was one district in Texas where if you filed in that district, you knew which judge you were going to get. He was a very MAGA type judge, very right wing, who was going to strike down on a nationwide basis, whether it was student loans or a healthcare issue or whatever it might be, was going to potentially change the law nationwide. So it is an issue that's come up both, like you said, against Republican and Democratic presidents and their policies. And I agree with you that Trump is, by any measure, taking actions that upend our understanding of how not only the Constitution is interpreted, which of course is the case here, and I think it's fair to say that he's essentially trying to cross out certain words in the 14th Amendment of the Constitution effectively, but also in other contexts, doing things like firing, an issue we talked about before, firing some independent commissioners in certain bodies and doing other things that upend our constitutional order. So I agree with that 100%.
Yeah, and I would also, just to put a finer point on it, every administration that has a nationwide injunction enforced against it is the one that feels harmed. And so during the Biden administration, I believe that during one of the Supreme Court arguments I think it was the Prestone case, the Solicitor General was asked about nationwide injunctions, and she suggested that it would have to be a issue that the court was going to have to resolve, because whoever is in office, they claim that they are being harmed when they are not able to enforce their policies. And so that's sort of kind of is what it comes down to. But that's all to just say that what the court was actually deciding here was whether this form of interim relief is something that district courts have the power to do while we wait for the final litigation to proceed. So it's not a question on the merits. It's about this particular kind of interim relief. And as you note, Justice Amy Coney Barrett, who wrote the majority opinion, takes great pains to distinguish between nationwide and universal injunctions, and she wants to call them universal injunctions. So I say, for purposes of our conversation, let's just use them interchangeably, because I think that's sort of in common parlance what they've been called.
That's right. I think that what her point is, and just so, because I think it's something that it's useful for listeners to understand, is that if, for example, you want to get an injunction against someone from doing something, like I want Elon Musk to stop doing X, and you bring a lawsuit against him and you get an injunction, that injunction can have an effect beyond that court's jurisdiction, because that court might have jurisdiction over Elon Musk and may say, Musk, I don't care where you are in the United States of America, you can't do this. But that's not what we're talking about here. What we're talking about is essentially whether or not a judge in one state could say this particular order, this particular statute, this particular rule, whatever it might be, is unconstitutional or unlawful and should be stricken on that basis, which would have obviously a nationwide or universal impact.
Right. So I would also say that I think that a lot of the discussion on this particular case has ignored an important nuance about how the court was framing this. So basically, as you said, Renato, this is about when a court issues an injunction against whom it can be enforced. Mm-hmm. And right. Normally a court is, dealing with the parties in the case before it. When it issues a ruling or some kind of an injunction, it will apply to the parties before it. And nationwide injunctions obviously go beyond that scope. And so the court is looking at, the scope of these injunctions and to whom it can be enforced. But I think there's an important concept that Justice Barrett mentions very early on, which is that she says the purpose of injunctions, the purpose of stopping something from happening, and in this case, the government from being able to enforce a law, an executive order, is to provide complete relief to the party seeking it. And I think that phrase, complete relief, is why this becomes complicated in one sense, because the question is, what does complete relief mean? And basically, what the majority says is, when we're looking at an individual or an association, complete relief means that an injunction stops the government from enforcing it against that person or the members of that association. In other words, to go beyond that would go beyond what the purpose of this remedy is and the power of the court. But it is interesting because while it seems pretty straightforward, I think what complete relief means might depend not only on the nature of the plaintiff, and we can talk about states, and how those play into this, but I think also the nature of the issue that is being raised.
I think that's right. And it has practical impacts as well, Asha. I mean, there are over, I think, 200 district courts in the United States, if I recall correctly, certainly well over 100. And as a practical matter, what this might end up meaning is that even if, like, let's just say you have a district court that covers an entire state and they ultimately, a state is the plaintiff, okay, that helps people in Alabama or Illinois or whatever state is litigating. But do you really then have to, unless the United States Supreme Court acts, are you literally going to have to be bringing the same case in all these different states when you have a law that impacts wide swaths of people? And I think that's the biggest concern that people have about this ruling.
Well, Justice Kavanaugh, we can get to his take on it, is yes. Yes, you just have a lot of different district courts, basically doing whatever they feel they need to do. And then there's this ultimate arbiter. But so, yeah, we can get to the concurrences, which is another reason why I think that this gets complicated. So, but just to kind of stay with Justice, I want to keep on calling her Amy Coney Barrett, but Justice Barrett, her opinion, she basically said, so she acknowledges that to give complete relief and limit it only to an individual plaintiff or, an associational plaintiff, meaning, the members, I guess, of that association or group is limited. And, the repercussions of that would be that, I'm about to have a baby, I go in and I have to sue and say, Trump can't enforce his EO against me. And because that doesn't apply to anybody else, literally every other mom has to line up and come in and get their own injunction, basically, which is impractical. But what Justice Barrett says is we have a mechanism in law that addresses this kind of situation. What the respondents were trying to argue, the respondents were trying to argue was that this had a historical analog called a Bill of Peace, and she goes into this whole historical thing, but she says no, a Bill of Peace wasn't actually a nationwide injunction. It was what we know today as a class action. And so she basically says, if you really have an issue where there are there's so many people that are affected and they are all similarly situated, we have a way through our federal rules of civil procedure to certify a class. And that will basically then allow it will prevent this floodgate opening of everybody having to actually sue individually in order to get relief for themselves. So that was her answer to the policy issue. That this is, impractical.
Yeah, I thought and that really is, I thought, very important to me. All right. I actually thought that this opinion was in many ways an attempt to be a more middle of the road opinion by sort of not going as far as it could have gone and saying, look, nationwide class actions exist. We're going to allow nationwide class actions. That's essentially what's going to happen in this case. It's already been filed. And that can solve the problem. Now, as somebody's litigated class actions, I'll tell you that there is a lot of hoops you have to jump through to get a class certified, and lots of ways in which that can be defeated. And that's going to potentially delay justice for a lot of people. I wouldn't be surprised, however, if federal courts inundated with these cases end up trying to find ways of reducing that burden in certain contexts, in certain limited contexts, but we'll see.
Yeah. So I have mixed feelings about this opinion. On the one hand, I agree with you that this is trying to find sort of this middle of the road and sort of is purporting to engage in this historical and originalist analysis. It seemed mostly persuasive to me, you know? I mean, it sounds like the first nationwide injunction was really issued in 1963. Like, it's not like this even, according to Justice Barrett, and she's citing scholarship, but, you know, she says it's not like this doesn't go back to courts of equity in England. This doesn't even go back to sort of the founding era. This doesn't even go back to really, you know, most of the 20th century. This is very much a recent phenomenon, and therefore, you know, we need to look to kind of another way. And in some ways, maybe this makes sense because, as we have seen, I think where you sit on the nationwide injunction issue really depends on your policy preference, right? Like, it's great when like the courts stop, you know, a president from enforcing something you hate. It sucks when it's, you know, a lone judge in Texas who's stopping, you know, women from getting abortions or stopping student loan forgiveness. I mean, from my perspective, for example, and I'm sure for other people that it's flipped. Here's my problem with her approach of, well, we need to look at history and we need to look at, you know, the original courts of equity, et cetera, et cetera. She says, we're not going to look at policy and what is practical and what makes sense, you know, in cases where things have nationwide import. The reason that this bothers me, Renato, is that this is not the way that they approached, for example, the immunity decision. I mean, the immunity decision, you have a wealth of historical scholarship and, you know, data that says that the founders did not anticipate that the president would be above the law. And, you know, I just did a Substack talk with Professor Zephyr Teachout about corruption and how this was on their mind. And I mean, there's just no way that they would have imagined that the president would have some kind of absolute immunity for actions that were taken with some kind of corrupt intent. And yet, what do? They say, but for policy reasons, we need to create this immunity because otherwise it would open the floodgates and courts would be, you know, flooded with lawsuits against the president. I mean, so it's just inconsistent. And so to me, you don't have credibility when you choose one, you know, jurisprudential approach for one case and a different one for another case. Policy matters sometimes, and sometimes you just can't take that into account. You have to look at history. And wow, isn't it just coincidental that you always end up at an outcome that happens to benefit a person who, you know, is along the political leanings that you have. That's where I found a big problem with her nitpicky historical approach.
Yeah, look, I think those are valid arguments. I mean, I think consistency in approach is not one that Supreme Court justices usually have, even the ones that claim they do. I mean, usually, for example, Justice Thomas is very focused on what words meant back in 1789 or whatever, you know, around the founding. But of course, he occasionally makes exceptions as well. So I haven't seen much consistency, even if whether I agree with the approach or not. So I think that's a valid concern. I think if we're going to get very realist about it, I think that part of what was actually happening in that opinion is that Justice Barrett was making a policy argument towards the end, in particular, when she was taking on Justice Jackson, who had a dissent, which I'm sure you're going to get to.
She got kind of punchy there.
She got a little punchy. And I think part of what she was saying there is we need to be concerned about having judges with too much power, exercising too much power, because they're unelected and it's almost impossible to remove them. And so there's a bigger threat that comes from that judge exercising that authority in East Texas or West Texas than there is in a president who you can ultimately get rid of and is there for a limited term. That you could debate that. I mean, that's a that's a debatable point. I will say I do think there's something to it. And I think that often at the times, I will say the left, and a lot of progressives have put their faith in judges to be sort of save them from whatever, and realistically organizing and mobilizing may be the better way to do it, because judges are not always reliable. And I think we've seen that, and you can end up with unelected judges that are in there for life, like we have currently in the Supreme Court, who are totally issuing all sorts of policy outcomes. And, now obviously that same reasoning could be applied to this Supreme Court, maybe exercising a little bit of humility and restraint in terms of their own rulings. But I do think that there's some aspect of that is appealing to me.
I think it's appealing in theory, but I think there's a thread running through the majority justices, including the concurrences here, where they're being very condescending towards district courts overall. And so, there is Justice Barrett's thing about, they can't exceed their scope. And we can talk about, again, the complications of this idea of complete relief that she hangs her hat on, because I don't know that that's necessarily crystal clear on how that works out. But you have a concurrence by Alito that says, well, just because we're saying that, you can use that class actions can be utilized, district courts, you better be careful. We're going to be watching you. Don't try to get sneaky and use class actions to get what you couldn't do, with nationwide injunctions. And then you have Kavanaugh, who's basically like, yes, let the district court serfs, kind of do what they do. And ultimately, really what matters is what we say. And so, pretty much kind of saying that on these kinds of matters that are really important, we're going to have the final say anyway. So who kind of cares if there's, a few weeks of kind of chaos or whatever, we, the grand poobahs of the law, will come in and proclaim, what is right and just. And so I don't know. I mean, all of that to me just put together felt like this is a self-aggrandizement thing that's happening here of their own institution as a court, even relative to other courts in its own branch. And that to me is one thing it did have in common with the absolute immunity decision, which is at the end of the day, we'll decide who's the king and who gets to basically be a dictator or not.
Yeah, I do think the concurrences, because you're kind of turning to those a little bit here, are interesting in that respect, because Alito in particular talks about how lax enforcement of the requirements for third-party standing and class certification would create a potentially significant loophole to today's decision. And I guess I'm reading the majority opinion like, okay, that may effectively create a what he's calling a loophole, but I thought was a feature of the majority opinion. And I think it remains to be seen how this turns out, because as a practical matter, I agree with you about the view that the Supreme Court has of district courts. But as a practical matter, they take so few cases, and they seem to, over time, they've taken fewer and fewer. So they weigh in infrequently. And there are issues that impact wide swaths of people on a regular basis. So unless the court plans to get in the weeds on class certification on a whole variety of matters and take on more in their docket than they otherwise would, or reshape their docket to really focus on this one issue, they aren't going to be the final arbiter of all of this. Ultimately, some district courts looking and applying their whatever sort of standard they think is appropriate for class certification and so on might end up being the arbiters.
Well, I think this is where the shadow docket comes in, Renato. You're right that they don't take cases on the merits, but the idea here would be that you certify a class, or the court certifies a class or a putative class, and then issues an injunction that can be enforced against that class, right? or that applies to that class. And that is still the injunction that would then be appealed up to the court. And what we've seen is that the court, when it gets to staying lower court injunctions, does this on its what Steve Vladeck, who we've had on this podcast before, calls the shadow docket, meaning that it's basically an emergency and an administrative docket. So they just say stay granted or stay denied, and they don't give any reasoning for it. So I think I would push back and say that's the exact point, that they're making decisions that impact a lot of people, but they're doing it through these mechanisms of issuing stays or denying stays that don't force them to, explain anything. They did this last week with one of the deportation cases involving third-party countries and torture. And so, again, it's another way to expand their grand poobah-ness of the law.
Yeah, I mean, look, I think we are going to have to wait and see how this plays out. I mean, Steve Vladeck, who, like you said, been a guest we've had on pretty frequently because he's such a cutting edge thinker on these issues, is really following them. I mean, to his credit, he popularized the term that you mentioned a moment ago, shadow docket and so on. But he, by the way, also talked to us about this issue of universal injunctions, nationwide injunctions, and that one district court I mentioned and so forth. So, I do think the devil's in the details here. And I am, concerned myself about the way in which the courts are consolidating additional power to itself. Ironically, Justice Barrett talks about, she's like, look, she says Justice Jackson decries an imperial executive while embracing an imperial judiciary.
Right.
And of course, I don't want an imperial judiciary, but if you really are concerned about an imperial judiciary, you have to be concerned about the court, the Supreme Court grabbing authority in an unwarranted way.
And yes, and you and I agree on that point. I caught that phrase too, and I thought it was also ironic. So just to kind of close the loop on nationwide injunctions, I think it's important where the opinion doesn't outright ban nationwide injunctions. It says that district courts can't give broader relief than is necessary to give the parties in front of it complete relief. And, what I understood is that there might be situations where the kind of relief they have to give either is directly or de facto nationwide. And I think one of the things that she leaves open for district courts to figure out, she's like, I'm not going to really get into the weeds on this, is what you do with states, right? So states, when they bring suit, what does it mean if the state of Connecticut comes to a court and says, this executive order that would deny birthright citizenship, to whatever categories that the EO purports to exclude, would wreak havoc in my state. It would cause chaos in the hospitals. It would cause chaos in our, city halls that issue these documents, et cetera, et cetera. So, I mean, Justice Barrett acknowledges that that's a little bit more complicated than the mother herself coming in asking for an injunction, or some group representing a discrete, number of plaintiffs that belong to that group. That a state is more complicated, and so she's left it open for the district courts to kind of, I guess, figure out or experiment with what complete relief means to a state, because right now, I mean, I think a number of blue states have basically, sued to get an injunction. And I just don't know what that would look like unless you were to say that it applies to every resident of the state. And, and even then, what does that mean? So if somebody is born a citizen and acknowledged as a citizen in Connecticut, then they drive to Texas, and Texas can then, sick ICE on them and have them deport. Like, you end up with this crazy thing if there's not some way to make it nationwide, unless you were to then invoke the full faith and credit clause and just say, like, anything that happens in the state has to be given the weight of, the law wherever they go. But that's still nationwide. I mean, I guess it would still apply only to the residents of Connecticut nationwide. But my point is, there is a way that in this ruling that still leaves, to use Alito's term, loopholes or kind of gaps that it doesn't fully address.
Right. I think that's part of the reason why I felt like some of the alarm about the decision is like too early. It's like too soon to tell, too early to tell about really the impact of this decision. It may be, there have been cases where you have one state that brings an action in federal court, and it's joined by all these other states that ultimately come in and join that state. So if 28 states challenge some federal law or an executive order or whatever, and a judge ultimately grants an injunction, does it apply? You have 28 states that all have their residents covered by that. The Supreme Court's going to have to look at it, and if it doesn't, it's effectively going to undo to a very large extent whatever the administration is trying to do. So it's just, I think this is like interesting, and it's very important, and it does limit courts' power. How it plays out in practice, I think, really depends on how courts, how district courts interpret this ruling and apply this ruling, not only regarding states, but also the nationwide class action. Whether they how rigorous the standards they apply for things like class certification, and then how the Supreme Court reacts to that. And I don't know, I can't be sure how a Justice Barrett or Chief Justice Roberts are going to respond.
Well, we know Justice Alito is watching very carefully. Those judges better be careful.
Yes, indeed. So, Asha, we're recording this on Wednesday the 2nd, right before the holiday weekend, and we had a big verdict today.
Yes, I know, and I'm excited to hear your take on it. So this is the P. Diddy criminal case, and I know that you had worked on a case very similar, the R. Kelly case, and I think there are some parallels. So, yeah. So what's your take? He was acquitted of the RICO charges, but then was convicted on 2 counts of the trafficking.
Well, he was acquitted of, so he was acquitted on RICO. Yeah. All right. He was also acquitted on, there were sex trafficking counts. He was acquitted on those as well. Oh. The only counts that he was convicted on, what's called the Mann Act, which is transportation. This was used, which was originally like the white slavery sort of act back in the day. It was meant because there was this idea that young white women were being trafficked and brought across state lines, were being plied with drugs and alcohol and plied across state lines. So it was originally for that purpose, but it is occasionally prosecuted. Usually I was handled a case that involved the Mann Act, but it was used because this person was doing other much more serious crimes. That's why it was charged. But typically, the federal government does not charge you with bringing a person across state lines to engage in prostitution in and of itself anymore. In other words, this came up with Pritzker, not Pritzker. I'm sorry, Spitzer, Elliot Spitzer. Big difference. Big difference. But Elliot Spitzer, when there was, I believe weren't there allegations with him regarding that? I don't
remember, but wasn't this also in play when we were at least talking about Matt Gaetz too?
Yeah, although for him, the women were underage, which is a different.
So what's the difference between the Mann Act and the sex trafficking? Like, what is is there like the coercion piece that has
the Mann Act is simply, I live in northern Illinois. Okay. I live near Chicago. If I hired a prostitute in Indiana and she crossed from the Indiana border over into Illinois and I caused that to occur for purposes of prostitution, that would violate the Mann Act. I could be indicted for that.
Okay.
In and of itself. And it doesn't matter whether I was just a customer, like in this hypothetical, which I'm not doing. I'm just using this as hypothetical. But for the trafficking, it's actually that like you said, the person is actually engaging in trafficking. And what they were trying to prove, that the prosecution, first of all, in this RICO conspiracy, set up this whole criminal enterprise that like Diddy and his friends were like this giant racketeering conspiracy. And it is similar to what the Eastern District of New York did in the R. Kelly case with their RICO case, but similar to, I would say, the overreach of RICO in a number of contexts. But then they also had the sex trafficking allegation. The allegation was that Diddy was bringing his girlfriends to, I'd say, highly reprehensible, these called freak-off parties where there's lots of drugs, and they were basically being coerced into having sex with male prostitutes. Very allegations that I think no jury would like. And they showed video of him beating his ex-girlfriend. So, I mean, this verdict is not a judgment on Diddy as a person. Okay. I think it's fair to say awful person, but I think it's really in many ways a reflection on the charges and how it was charged, because essentially what you had here was a case in which the prosecutors charged more than they could prove. And that caused the jury to distrust the prosecutors, because essentially at the end, what the prosecutors were arguing, because there were text messages and that showed that the women were willing participants in certain circumstances, was that if in one case, even in one instance, if someone was not a willing participant, then that was sufficient for sex trafficking, that she was being coerced to do it. But it was very hard for the jury to get themselves beyond a reasonable doubt on that, when the prosecution was portraying Diddy and his entourage as essentially a racketeering conspiracy involved in sex trafficking, when it was really a dude with his girlfriend and who was abusing his girlfriend at a certain point in time. So I think there was I don't know, I wasn't in the courtroom, but the jury clearly had some sort of disconnect there with the prosecution's approach.
And I know we talked about this when these charges first came out, but what's the point of using the RICO charge? Is it that you can then bring in kind of all of these different acts? And because we've seen this, there's this case we saw happen at the state level in Georgia with the election stuff, which is sort of, I guess it seems like the advantage of RICO is it allows you to kind of bring in these like subplots.
Yeah, it allows you to sweep in
one big thing.
Right. I mean, look, let's just be real. If Diddy was charged with bringing people across state lines to engage in prostitution, and that's what the charge was, and even if he pled guilty to it, people would not have treated this case the same way. It was a way for them to rope in a lot of things where they're like, he assaulted women, striking, punching, hitting them. That was part of the scheme, essentially what's called the enterprise. He was using all of these other people and his businesses to cover up his, quote, abuse and commercial sex. I'm looking at the indictment now and reading from it, and it was a way then also for evidentiary purposes for them to sweep in a lot of stuff. Because otherwise you'd have a very sanitized trial. Oh, this is all about him bringing someone to get across state lines. Like, okay, person X, are you a prostitute? Yes. Were you engaging in prostitution? Yes. Or, it would be a much more sanitized indictment. They wanted to get all this in front of the jury. He's been in custody this whole time.
Yeah.
And
yeah.
Fight about that, because you usually wouldn't have someone in custody for engaging in prostitution, like pre-trial for many months. And
if it was just the prostitution, all of this other stuff the defense would say this is prejudicial, that it is not necessary, especially since there's no element of coercion. The elements are quite simple. And so any of this other stuff would be considered too inflammatory and prejudicial to bring in.
That's right. And so, I mean, this is an interesting case in which, there's no question that some of the things that the jury saw were just absolutely horrific, and no one can defend what P. Diddy here. No reasonable person could defend that the conduct, which is absolutely disgusting and reprehensible. And I think that a lot of juries might have convicted just because they thought he was a bad guy and should be behind bars. And that's not what federal prosecutors are supposed to be making charges on. And this jury was focused by this judge on the elements, and the defense in this case did do that. And that's why you have a verdict in which the jury was clearly looking at the elements. And, there was one charge they couldn't get a full agreement on, but they did acquit him on a number of charges, and they found him not guilty, or they found him guilty, on the Mann Act, because that's very straightforward. So it struck me like a jury that was really thinking about the elements and the instructions. And, it's an example of things that, look, no one's going to feel too bad or wouldn't be crying any tears for P. Diddy. But it's a tactic that's used in a lot of cases by prosecutors where they will overcharge a case. And it sometimes will result in a defendant taking a plea or feeling a tense amount of pressure because there's so much brought against them that they better plead to something. And here, obviously, this guy had all the resources in the world to put up a fight and so on. But it's definitely an interesting verdict from a perspective of somebody's a trial lawyer. And
it sounds like they considered this a victory.
Oh, he was thanking God, supposedly.
Yeah. So what is he looking at then? I mean, he has been in custody for the last year. The lawyers have asked for him to be released, I guess, until sentencing. And so what would a sentence look like here?
So the government was proposing something it was suggesting that in the court that the guideline range is something in the 40, 50 something month range. Okay. I'm sorry.
That's not nothing.
No, it's significant. Of course, he served some time already. He would get credit for that. But that's the guideline. That's what the government would be recommending.
Yeah.
And typically judges, particularly in the Southern District of New York, go well below that. And so, in a typical case, let's just say this was a Mann Act case. They charged random, man, John Doe, and those are the guidelines. You would expect the judge to go far below them. However, an interesting thing is, the judge has to consider all of the defendant's conduct. In fact, what the statute requires, it's 18 U.S.C. 3553A, requires a judge to consider the history and characteristics of the defendant. That's a direct quote from the statute. Also, the quote, nature and circumstances of the offense. So the judge, you could see the judge, because there's two convictions here, Mann Act convictions, they're each 5-year sentences. A judge could say, I'm going to give him the full 10 years, which almost never happens, because I witnessed video of him beating a woman. I witnessed certain things about this conduct. It was outrageous conduct. And I believe this is necessary to protect the public and to deter others from similar conduct and so on. So I do think there's more of a range of where the judge could go with this than you would see in its usual case.
And how much deference is that judge's determination given if he wants to appeal? Because I would imagine that if he were to do that, there would be an argument that that's unfair. I mean, he was acquitted on the charges that encompass that conduct, and then to take that into account to kind of, especially to go beyond what might normally actually apply in this case, or any other defendant, that is somehow he's been targeted.
Yeah, it's really interesting. So if you have a sentence within the guideline range or below, it's presumptively reasonable.
Yeah.
So anything below that 40, 50 month mark or in that range is going to be presumptively reasonable. Hard to get overturned in appeal. But if the judge goes above that and does it based on these findings, it'll definitely be looked at, and the Court of Appeals is going to consider that. It is interesting that there has been have been court cases about this, that judges can't consider acquitted conduct. They only have to find by a preponderance whatever they're considering at sentencing. And it's a way that the idea is that it takes power away from prosecutors, because prosecutors can't charge bargain with you. In other words, they're not no matter what you can't have a deal with the prosecutor where they charge you with something small and then you're getting away with something else or something along those lines. But really, as a practical matter, what it does, in my opinion, it gives a lot of power to prosecutors because they can charge you with some small thing and then put all this in front of the judge, and the judge, without proving it beyond a reasonable doubt, and the judge can consider that and do whatever he wants, in this case, or she wants.
Yeah, that seems a little sketchy to me, to be honest.
Many believe it's unfair. It's definitely hotly debated. And I think this, Diddy is the sort of person who has the means and the legal team to fight this, and he could. And so I think this is in the context of what he did, which is reprehensible. This is a very 90th percentile outcome for him, given all of his abhorrent conduct. And so now, I don't know what the judge is going to do. The judge could just go with whatever the guidelines end up saying, although there'll be a debate there. And like I said, usually in the Southern District of New York, you would expect an outcome below the guidelines. So I think it's an interesting case from a legal perspective. Obviously, from a moral perspective, I'm sure we're all, just disgusted by some of the behavior that was described at this trial.
Well, don't be too sure. Just as another tangent to this, I'm someone who's always kind of monitoring the disinformation space and or the information space, I guess, really. And one of the things that I was seeing is how influencers, and particularly sort of the, male rage influencers who, are all about how life is unfair to men, how these big court cases like Johnny Depp and Amber Heard and these are kind of being enlisted into the culture war narrative as examples of how men get railroaded or something for, I guess doing what boys will be boys or whatever. So I just point that out because you said we all have a consensus on this. I just want to flag that I suspect if the sentence is harsh, and especially harsh, that it could become a culture war issue.
Well, we'll have to see what happens at sentencing. But I will say that this case has been full of surprises thus far.
So, Renato, before we go, we are heading into the July 4th weekend. And I have to say, the 4th is one of my favorite holidays.
Really? Why?
I don't know. I feel like I have good it's summer, so it's sunny. I feel like as far as, impositions and responsibilities go, it's not as fraught as, say, Thanksgiving, for example, but you still, often get to see family and hang out with friends. I like that it celebrates something that ought to unify us. So just as, from a kind of a civic pride kind of thing. And also my favorite Schoolhouse Rock video, which I always post on every July 4th, is No More Kings. And that I just like the whole vibe.
I do too. I will say though, for me, my birthday is the day before July 4th. It's July 3rd. Tomorrow.
Happy birthday.
Thank you. And my mom's birthday is July 5th.
Okay.
And so it's always tied to birthday celebrations to me. So this is actually the first weekend I will not be celebrating with my mom, because my wife has a family reunion that we're going to be participating in around the same weekend. It's sort of like an every X number of year thing. But I did take my mom out to dinner last night, and we did presents and all of that because it's a big deal. And I loved it when I was a kid because it felt like I got like a celebration and all holiday and
fireworks,
all this stuff. Everything. Yeah. All around my birthday, which was super cool.
So you're going to a family reunion as a plus one, or I guess as a spouse. I'm going to a family reunion this weekend. Yeah, an extended family reunion, like all the aunties and uncles and people
Same
that
here.
I related to in ways that I don't fully understand. So how do you feel about it? Is this, you've gone to this before, it sounds like.
No, I have not. So this is going to be interesting. We did not go. I was not able to go last time around. And so we'll see. It's fine. I mean, it's one of these things where when it's not your family and there's, 100+ people who you don't really know, it is what it is. But obviously when you're a spouse, you support your, in my case, my wife, right? So you do what you got to do.
Are there matching t-shirts?
Yes, there are t-shirts. It's a whole thing. It's like, okay.
Yeah. Is there a cultural program?
Yes, because my wife is Jewish. And so there's a whole Jewish thing. That's so sweet. I'm not Jewish. You can tell by my name. Was there with you as well?
Yeah, there's cultural programming for Indian culture in particular, like the village. This is my dad's side of the family that they're originally from. So there's food and, the music and all that kind of stuff. And then separate from that, there's a youth talent show.
Oh, wow. Is your daughter going to be participating?
This is the thing. My kids never want to do the talent show and I'm mad at them.
I get that. Like when you're a kid, because a teenager is not going to think that that's cool, right?
Yeah. So they, because I feel like I'm now, finally having been subjected to this when I was growing up, I now get to force my children to be in the talent show and show off and get, bask in their reflected glory and everything. If they're not playing along. However, my son is going to be on a panel.
A panel? Well, you have a panel?
We have panels.
It's like a conference.
We have a panel on doing volunteer work in India. So,
oh my God.
Yeah, it's come a long way. When I was growing up, and I'd be interested to know more about your wife's, experiences and how it's evolved over time. This all started, of course, my parents' generation was the first generation that were here. So when I was younger at these family reunions, there was always a youth versus adults debate.
Never heard of that.
And it would be about should we be allowed to date? And the Indian parents would all be like, no, you should never date. And the kids would be like, we should be allowed to date. Why did you bring us to America? If you should have just stayed in India if you didn't want to, be a part of the culture here. So it would get very heated. But I guess now we're past that. Now we have panels on doing volunteer work in India.
Wow. This is interesting. All right. We have to next week come back and report on our family reunions. Yes.
I want to hear about the programming. Oh, and I also want to find out if there's a skit. If they do, if the kids do skits.
Wow. I wish there'd be like whatever, tandoori chicken and naan and butter paneer, things like that at my reunion I'm going to.
Maybe we can combine them.
That would be great. I'll trade you.
The Om Shalom reunion.
I love it.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.